Our next speaker is Conor Powell. Conor is a practicing counsellor. He practiced in public law, including child law and human rights law, and has lectured on the Trinity Diploma in Child Protection. Mr. Power's talk today will include constitutional rights of children and constitutional and international law in relation to the child. So I'll pass you on to Conor now.
Oh, that's great. Hi, everybody. Conor Powell here. I hope you can all hear me. I actually can't hear you, and I'm afraid I couldn't hear Sarah there. Thanks very much. Good morning, everybody. Conor Powell is my name. I'm here to speak on children's rights. I guess my talk is going to be far more objective, I'm afraid, than the very subjective and personal and excellent speech by Catherine just there. So you'll have to bear with me, I'm afraid, with that. First of all, just to say, when we're discussing the legal rights of children, there is a hierarchy of laws, and as social workers and practitioners, you'll be aware of statutes acting within the Child Care Act 1991, for example. But there is a hierarchy, and at the top of that, there is EU law. It doesn't really impinge on the topic we're talking about today too much, but it is relevant, for example, for child abduction. But it's also, when it speaks of children's rights, it does say something to us about what it means at a broad federal level like that. Of course, our constitution will be the main focus of the talk today. I'll come back to that in just a few minutes. And then statutes, everyday statutes, acts of parliament, acts of the Oireachtas are what the bread and butter of our law is, be it the Education Act, Special Education Needs Act, be it the Child Care Act 1991. And then one of those also brought in the European Convention on Human Rights, the ECHR, into our law. And Article 8 of that is something you might have all heard of, which deals with the rights of right to family life at home. And that's the European Convention version of our protection of the family, but it's much broader. It protects what we call de facto families, families outside marriage as well. And that's quite interesting. There is in our system, of course, soft law, policies, circulars, and indeed international agreements such as the UN Convention on the Rights of the Child that also have an impact on how practice operates. And a lot of our institutions have very good policies and circulars that are guidance for us. They're kind of soft law. They might not be hard binding, but they're kind of presumed to be the position one would adopt unless the law says otherwise, for example. And all of those documents are subject to application in daily practice by social workers, etc. And then when push comes to shove, in the case of dispute, by interpretation by judges in cases in court. And that's how lawyers get to know what the law is, because we can read the EU law, we can read the Constitution, we can read statutes, but actually in practice, it's in cases in court where the detail is really filled in. And of course, each case throws up its own individual subject matter. Just to deal very briefly with EU law, it doesn't really impact on our practice too much, but some of you will have come across child abduction. That's an area now regulated by EU law. EU law is only applicable for certain areas, but where it is, the EU Charter of Rights, it operates at a very fundamental level so that all institutions of the European Union and indeed all courts of the member states and agencies of the member states that are implementing EU law must operate in conformity with the the EU Charter of Rights. And Article 24 of that recognises children's rights in the following way: children shall have the right to such protection and care as is necessary for their well-being. They may express their views freely. Such views shall be taken into consideration on matters which concern them in accordance with their age and maturity. Now, I won't read the rest of it just now, but actually that's a very modern statement right there. That wouldn't always have been in constitutions or, fundamental charters of rights. It's something that really starts in 1992 with the UN Convention on the Rights of the Child, saying, giving vent to the view that children have rights in and of themselves, and their views must be respected by agencies. So that's a very modern view there. And the EU's Charter of Rights is a very up-to-date document on that. And we'll see that Irish law has also caught up with that in recent times. Our state is established by the Constitution. It's the fundamental legal document of the country. And as such, all laws in Ireland must conform with what the Constitution says, with the exemption of EU law, which operates on a kind of a federal level, and all member states must operate EU law. But other than that, within Ireland, the ultimate determinant of what the law is the Constitution. Now, it's a broadly based document, and it sets out what the Oireachtas is, it sets out what the President is, for example, but it also sets out fundamental rights and the fundamental rights of individuals, including children. And actually, there's been a long recognition by the Irish courts that children are rights bearers. In other words, that children inherently can be the subject of having rights. That's not something, by the way, in history that was always available. It was something that was more modern in its creation. But the Irish Constitution recognises children as having the locus for two rights. One, as individuals, as children, they have personal rights. They have rights pretty much the same as adults can have rights, though we'll say that they're not necessarily the same rights. They also have rights, of course, as family members, as everybody within a family does have. So they enjoy the same, or at least I pause to say similar fundamental rights as adults. Most rights in the Irish Constitution you describe as civil and political rights, freedom of association, equality before the law, the right to expression. These are your engagement in public and with public authorities. And most constitutions have a lot of these rights and less of what we might call social and economic rights, a right to housing, or a right to adequate health care. There's one right, of course, that children do have that would be in that category, which is the right to free primary education. That's guaranteed towards every child, and we'll come back to that in just a few moments. But at a fundamental level, then, the Irish Constitution looks at things in more process terms. Most constitutions do. And even where there are economic and social rights, there are very few absolute rights, it has to be said in any case. Question mark nowadays as to whether the child's right to have the child's best interest is a constitutional level, and we've solved that now by the constitutional referendum in 2012. And just to go on to that, you'll all be aware that the Constitution did change in 2012 with the 31st Amendment, sometimes called the Child Rights Amendment. This was caused by the Irish Constitution putting the marital family on a kind of constitutional pedestal. And what I mean by that is under Article 41, the family is recognised as the fundamental unit group of society. But the family that's defined there is not, for example, any old family. It's the family based on married parents. And that actually remains the case. And the knock-on consequence of that was that certain children within those families were deemed to be greater protected by the families than children outside marriage. This had a peculiar effect. Although the rights of the children were the same, this manner in which the state could, for want of a better word, intervene in those families was affected, because the family that was based on marriage were able to put up greater legal barriers to state intervention in terms of childcare, etc., than families not based on marriage. Non-marital families, be it single parents or be it families who weren't married. But of course, the problem with that was you're kind of creating a category of persons with certain rights and others without rights. And in reality, the situation of all of them is quite similar. This was kind of a legal issue. It's not a legal issue that's gone away. The distinction remains. But because of the referendum in 2012, from the child's perspective, it really is almost extinguished. The locus, of course, of child welfare remains in the family. And in Irish law, both in the Constitution and in the Childcare Act, the family remains the fundamental unit group of society. But that family remains based on marriage. But we'll see that the rights of the child now go beyond that family. And the right, the counterpoint, the obligation on the state to protect the child's welfare now inheres more clearly in all children, not just those outside marriage, but those inside marriage as well. But which I mean that the legal burdens in intervening in families where appropriate in the child's best interest was lessened. And that was a concern because time and time again, when push came to shove, the Supreme Court would have to say, well, look, there's a constitutional presumption that children are best with their family. And that's absolutely fine, of course, as a matter of principle. But when at the matter of practice, it was intervening or lessening the means by which there could be valued interventions with families, that was causing a problem. So one of the answers was Article 42, capital A of the Constitution that was voted on by the people in 2012. And it says the state recognises and affirms the natural and imprescriptible rights of all children and shall, as far as practicable, by its laws, protect and vindicate those rights. So that's a recognition that every child holds rights. And that was a statement that wasn't in the Constitution as such before that in such a deliberate way. It puts it beyond doubt. It makes it clear what was already implied, that children have those rights and the state recognises it. Now, that must mean something. That must mean that children as rights bearers can look to the state for certain protections. And one of those protections then is in relation to care in general. We'll call it protection from harm rather than in a broader sense for now. And again, the Constitution now regulates when the state can intervene to protect children. And that's in Article 42, capital A, Section 2, paragraph 1, as it's called. And it provides that in exceptional cases, which is already telling us now this is supposed to be the exception because the family is obviously the primary protector of the child, where the parents, and here's the important words for this purpose, regardless of their marital status, and that's the change really, fail in their duty towards their children to such an extent that the safety or welfare of any of their children is likely to be prejudicially affected, the state, as guardian of the common good, shall, by proportionate means, as provided by law, endeavour to supply the place of the parents, but always with due regard for the natural and imprescriptible rights of the child. That's a very careful balancing. It takes wording that was in the Constitution, it expands on it, it broadens out the right of the state to protect children, regardless of the marital status of the parents. In other words, married parents can no longer put that up as a roadblock, potentially, to the state intervening in the marital family, always with due regard for the natural rights of the child. So what does that mean in effect? Well, it means in effect that childcare interventions, where they are proportionate and lawful, carried out in accordance with the Childcare Act, are undoubtedly, are undoubtedly constitutional. And it just took away any doubt that there might be about the lawfulness of state action. And the state, of course, as an entity, can only act in accordance with the law. There's a really important principle, not just of democracy, but of what's called the rule of law. The state must abide by the rules. Also, that amendment said that provision shall be made by law that in the resolution of, and I put there just specified children's cases such as custody, access, etc., childcare, the best interests of the child shall be the paramount consideration. It puts a very child-focused centre in the Constitution, and saying that when issues are for decision by a court, when push comes to shove, the paramount consideration is that of the welfare of the child. Now, it's not the only consideration, but the paramount means the first and most important, in effect. It's the one that should determine the outcome, though it's not the only consideration. Also, more protection for the ascertained, for the views of the child in such cases, having regard to the child's age and maturity. Again, a recognition that as children get older, their views of their own welfare should be determinative where that's appropriate. And must in any case feed in. It does, of course, remain a fundamental tenet of our constitutional law and indeed of our statute law. I'll come on to that in just a minute, that the best interests of children are secured within the family. And now that's kind of regardless of marital status, I would have thought. The state can only intervene to secure the best interests of the child where there is a failure by the parents. Now, that failure, by the way, isn't necessarily pejorative. What I mean by that is a failure can be either abuse, which is obviously pejorative, or it can be neglect. So it's a failure in terms of looking after the children. It's a failure to protect the children. It's a failure to provide for the children. That's the constitutional test. And we're not looking necessarily for blame or fault all the time. That's an important consideration. But the state, as I said a few moments ago, must act by law. And that means there has to come a tipping point. I mean, the difficulty with law sometimes is that it gets adversarial. Once you go to law, you're fighting. People lawyer up. It's not exactly a mediation. It's not necessarily collaborative. And so the danger of going to law is you get lawyers and you get law, and it can be a very tough adversarial place. It's the objectivity, as I mentioned at the outset. So there has to be a rule as to what determines. And in general terms, unless the state has the power of compulsion, the parents determine. Parents rear children in our constitutional regime and our statutory regime, not the state. Now, it sounds very kind of, anti-communist or whatever else. But what I mean by that is the rules in the Constitution must mean something. And so our rules say that parents are the people who rear children and who make the decisions for children, unless somehow that doesn't match a standard which is detrimental to the children's health. And then if it's appropriate and proportionate, the state can intervene. So a good example of that a few years ago was the PKU test case, which I think many of you would be familiar with, the PKU test carried out at birth for various diseases. And a couple of parents in 2001 said, well, look, we don't believe in that test. We don't want to do it. And the then Northwestern Health Board went to the courts to get a declaration that they could, in fact, force the parents to carry out that test. And they lost. The Supreme Court said, well, look, this isn't set down in national legislation. This isn't something that parents have to do as a matter of law. This is advisory. And as long as it remains, at least as long as it remains advisory like that, the parents decide. Even if the doctors think it's for the best interests of the children, that doesn't necessarily prevail in every case. You don't have rule by doctors, we have rule by parents. That means something. Now, and examples, for example, were given by the judges. Said, look, parents take risks all the time. They allow children to cycle to school. There's an inherent risk in that. So what they're saying, they weren't being flippant, by the way, in saying that. What they were doing is risk assessment. That's just because there's disagreement doesn't mean that parents' views doesn't count. So that's in effect what the courts are saying. There's kind of a dialogue. There has to be a risk assessment dialogue, and of course a tipping point. If parents are being reckless, or if their decision isn't really child-centered, or if there are other nefarious motivations behind it that in fact would be detrimental to the child's welfare, then I think obviously the state could possibly intervene. Also important in that case was the fact that there was no legislation for it. So the courts are saying as well that if Parliament determined that there had to be this test carried out, that might carry greater weight. Whether Parliament could mandate for everybody without a conscientious objection or something like that is a different issue. But in any case, that remains to be seen. Possibly in the context of mandatory vaccinations, that have been issues that have to be addressed, and that's been debated in recent years. But ultimately, as I said, parents rule, but the state can intervene if there's a failure on their part to protect their children. So it's a balancing act. There has to be dialogue as between the two. And the courts, as I said, have always recognised what children's rights are and that children's rights exist. And you see this back in even 1980. It seems like a lifetime ago now. But in a case called G versus An Bord Uachtaile, the adoption board as it was at the time, the child has the right to be fed and to live, to be reared and educated, to have the opportunity of working and realising his or her full personality and dignity as a human being. These rights of the child and others must equally be protected and vindicated by the state. In exceptional cases, the state is given the duty to intervene. And you'll see that's not too much different than the law is now. The law we now have under the Constitutional Amendment is an adaptation of that and modernisation of that. So the protection of children there often, of course, in this context is from the parents, unfortunately, or from parental neglect. And the state is obliged to protect children's welfare, and the state is obliged to intervene when parents fail. And the primary means by which that's done is the Child Care Act, which creates an obligation in Section 3, a general obligation on the Child and Family Agency to intervene to protect children, and also a statutory presumption that recognises the constitutional position that children are best protected within the family. And you see that in the terms of Section 3. It's a function of the Child and Family Agency to promote the welfare of children who are not receiving adequate care and protection. And Section 16 creates a more specific duty to intervene where children are not getting that. But in doing so, the law says that the CFA must identify children who are not receiving adequate care and protection, and then, having regard to the rights and duties of parents under the Constitution, regard the welfare of the child as the first and paramount consideration, and insofar as practical, give due consideration to the child's view, the wishes of the child. Again, that's quite a good encapsulation of what the balancing rights are: the interests of the child, the interests of the parents, the wishes of the child, and the role of the state. So they're the various interests that have to be balanced in doing that. And there's a statutory presumption there at Section 331C, have regard to the principle that in general it's the best interest of the child to be brought up in his or her own family. So that's a high threshold for removing children, by the way, and for intervening. And one could say that in so doing, and with that general principle that children are best in their families, that's an obligation to cooperate as well. And you can see that in a recent case, G versus the Child and Family Agency, which is kind of disproportionate impact. So the greater the intrusion is, the ultimate intrusion, of course, being a childcare order under Section 18, taking children into care, the more it has to be justified. But there can be lesser interventions, a supervision order or advisory, or just getting in there for viewing to see what's going on. And so they could happen maybe in broader circumstances, and that's proportionality. It's a spectrum of what you can do in your practice protecting children, depending on the need. And the Supreme Court in 2018 said the greater the restrictions on access, in that case by parents and members of the family, the greater justification there must be if the underlying aims are to be achieved and if violations of rights under the Constitution are to be avoided. And you'll see there the Supreme Court there cited Eriksson in Sweden, where the European Court of Human Rights noted that paragraph that the mutual enjoyment by parents and children of each other's company constitutes a fundamental element of family life. So interfering with that is something the state has to justify, and the greater the interference, the greater the justification must be. In other words, the greater the risk to the child. So that's a gradation. And you see that at one end of the spectrum, obviously, the terrible cases you've all come across, where children have to be removed. And the spectrum comes back from that to cases where it's really more providing assistance to family. And pretty anything up to the bad cases is probably a collaborative approach, is probably what the Constitution and what the statute law would have in mind. There are, of course, issues in the Constitution of the economic and social rights that services to children in terms of their protection. And the greatest one of those, of course, is education under Article 42. Even that recognises that family is the natural and primary educator of the child. But the state is mandated to provide a certain minimum, and parents must provide a certain minimum, and the state is obliged to provide for free primary education. The word "for" there in recent times coming in for a lot of commentary. It's the device that says that, well, the state shall provide for it, but not necessarily provide it. In other words, if it's been provided, that's okay by private means, then the state doesn't have to. But the state, in fact, does, of course, subvent all education in the state, both public and private, and you'll see that because, in fact, in the Constitution, they're mandated to do so. The education under consideration here is defined in broad terms. It's different to nurture. It isn't that, but it is education, and it's not just scholastic. It's like what happens in schools, but it's not just that. It is, of course, the promotion of the child's inherent skills and the child's inherent capabilities such that they can grow to become an adult. But it's not limited to that, of course, because the state is also obliged to educate children with learning difficulties. And you'll see that in the case of Donoghue, the Minister for Health, 1996. And even in that case, the High Court felt that there was a need for continuous learning to ask the effect of holidays. And of course, at the moment, if there's a need for continuous learning in the context of a child with special difficulties, one might wonder what the effect of a prolonged COVID cessation of schooling might be. I only posed the question. I don't know yet. Obviously, COVID is something totally different to holidays, and obviously the threat to welfare by going to school potentially would outweigh the right to education. But it's a very delicate balance right there, not necessarily straightforward. But there are dicta from the courts to say that everything has to be proportionate there. We know from Sinnott and the Minister for Education that the right to education ceases at age 18. But that's a kind of a blanket approach taken. Sorry. I want to deal very briefly, if I can, with Article 8 of the European Convention on Human Rights. This kind of dovetails with our Constitution. It's handy for families not based on marriage because it protects relationships not based on marriage and children born outside marriage, as it might have been back in the day. There's a positive obligation to protect family rights here as well. This inheres in care cases. And you saw the Supreme Court in the recent case that I just mentioned a moment ago, referring to Eriksson in Sweden, one of the first European Court of Human Rights cases on care. And that was about access and ensuring access to children. Why was that? Well, the European Court has always been focused on this issue of having no drift in care. And the European Court, this comes from proportionality. All very good that the state can take children from parents where that's justified, but they have to come up with the aim of it. What is the aim? If the aim is parental unity, then you must keep access, and access is very important for the right of the child and also for parents if the aim is reunification. So this is about no drift in care, not making a decision about what's going to happen, what the placement outcome should be. And ultimately, of course, in Irish law, we see that's for social workers, but ultimately for the court in Irish law, and the court under Section 47 of the Child Care Act can always make directions in that. But so, for example, in recent 2006, the European Court said, well, you can't take children into care just because the parents are having marital difficulties. You've got to assess that. And that's a collaborative approach right there. But that's what the court is saying. You can't, the grounds alone of parents having difficulties isn't sufficient. And in one case, happening in Ukraine in 2008, parental blindness. The parents were both blind. And in that case, the court said, well, that in itself is not a basis for taking children into care. The state has to necessitate, in that case, Ukraine has to investigate the need for investigation, need for supports to see if the parents can nevertheless provide support. I do want to mention one case, if I may, and I'm sorry, I think I've just gone slightly over time. Laban and Norway, 2019. This is a fairly recent, fairly big case from the European Court of Human Rights. It's what we call a Grand Chamber case. And here was the authority's decision to remove the mother's parental authority and allowing the children's foster parents to adopt them. And that was found to violate Article 8 on the limited evidence, because there simply wasn't enough evidence, they said, to justify this decision. It was kind of presumed that the mother who had the child outside marriage and had placed the child in foster care had kind of ceded her rights. And they said a few statements that they're kind of recalibrating. And I should say there's another case before the Grand Chamber called Ibrahim in Norway that will be for decision sometime later this year, early next year, God knows, that is of the same vein. So the European Court is kind of ramping itself up from this Laban decision of last year. It says a care order should be regarded as a temporary measure to be discontinued as soon as circumstances permit, and that any measures implementing temporary care should be consistent with the ultimate aim of reuniting the natural parents and the child. Very interesting statement there. They really are ramping that up. A positive duty, they mentioned, on states to take measures to facilitate family reunification as soon as reasonably feasible, subject to its being balanced against the duty to consider the best interest of the child. In other words, ordinarily, the aim must be reunification of the family, unless that's not in the child's best interests. Sorry, I thought I had one remaining slide. In any case, I'll finish up there, and I see the questions are coming in. I'm sorry about that. So the first question was when. Thanks for it. There are two questions, Bernie. Thanks very much, and I'm sorry for going over time. Drew, could you flash that question? Sorry, question one. When looking at a collaborative or interagency working, how do we ensure that all agencies take their responsibility, not just TUSLA? Well, that's a good question. Well, all agencies, depending on the agencies in question, I'm going to assume they're statutory agencies. How do you ensure it? Well, agencies, our state agencies, must operate in the rule of law. They have a remit. They have a public duty. They must carry that out. Now, they might say in individual cases that they have a broad public duty. Individual cases might be, they might say that's dependent on various factors. Ultimately, how do you ensure it? Well, you go to lawyers, you get a legal answer, I'm afraid, and the answer is mandamus in the High Court, an order directing them to carry out their functions. But the problem is we come back to this kind of no absolute rights. So if it's an agency that's to provide services, for example, well, there's no absolute right to a defined service. So, for example, in some cases, for autistic children in the past, parents were seeking specific remedy, a specific school or specific type of education, and the courts were saying, "Well, look, you were offered this over here, and that actually matches your need. So once your needs are matched, you don't have the choice thereafter as such. It's not the parental choice isn't there." But if there's a basic failure of service provision, then the answer would have to be mandamus in the courts. The soft power then of reminding agencies that they have a role to play is the important one. I hope that's not too vague an answer, and I'm sorry if it was. And then question number 2 is, what's the legal situation where a parent states that they can no longer care for their child with the ASD or moderate intellectual disability and refuse to take the child from school? Tussler refused to get involved, stating it's a disability issue, and the HSE voluntary agency provide crisis placement and residential placement, and the parent does not engage with services and is not actively involved in the child's life, which makes decisions for the child and monitors how there's an actual case. Well, I don't really like commenting actual cases. I'm not being smart about that. It's also a very long question, I'm afraid. Parents, I mean, look, you have to take it in stages. I mean, first of all, the child obviously has needs here, but it's not with ASD and moderate intellectual disability. It wouldn't be a need that would justify a care order as such, but it might justify a supervision order, and that might at least force engagement with the parents. I mean, the parents are to engage, but they refuse to take the child from school and just don't get involved. Okay, it's a bit I'm really sorry. I'm not going to be able to give a helpful answer to that, and I'm sorry if I'm doing a dodging that question. Who makes decisions for the child and monitors their welfare? Well, ultimately, that's your collaborative approach, primarily as parents. But if parents aren't looking after their children, then there should be a referral to TUSLA, and that has to be the short answer, I'm afraid. Thanks very much. It's a short kind of presentation of what constitutional rights are. I hope it was focused enough for your needs, and I thank you very much for listening.